that? The genetics?
They've taken a liking for sure, and I'm very grateful. I mean, I don't think I could literally have anyone better in my corner, and they're just they continue to blow me away with how just real they are and how kind they are. And
hey besties, welcome back to the channel. It's your go-to spot for all the latest celebrity news, legal drama, and behind-the-scenes insights that you won't hear anywhere else. Now, today we're diving deep into a story that has completely exploded over the past 24 hours. Blake Lively, yes, the Blake Lively we all know from Gossip Girl, and It Ends With Us, is apparently panicking big time about her ongoing legal case. And when I say panicking, I mean it. She is allegedly terrified that her case could get tossed out entirely. That's the only way I can describe the dramatic filings that went down in court just last night. To give you some context, I had just uploaded another video recently discussing Blake's motion for trouble damages under Section 47.1, and things have escalated even further. Yesterday, Blake's attorneys filed a request that is, quite frankly, eyebrow-raising. They are asking the court to deny a motion for judgment on the pleadings, claiming that it's untimely. And if, for some reason, the court doesn't agree with that, they're asking for an extension of time to respond. Now, here's the kicker. The very first thing they ask for is a denial outright. On the surface, it might look like a full-blown opposition, a comprehensive counterargument. But when you actually read the document, it turns out that's not the case at all. To add to the drama, Blake's team is also requesting nearly a month to respond to this motion, which is unusually long in cases like this. Their filing states, and I'm paraphrasing here for clarity, that Miss Lively is ready to respond to each and every argument presented by the defendants at the proper stage, whether that's at summary judgment or at trial. But here's where it gets interesting. The Wayfair defendants, who are involved in this case, apparently sat on these arguments, which they claim are significant, for nearly 9 months. According to Blake's attorneys, forcing the court to address these arguments now would result in redundant briefing, a waste of judicial resources, and would unfairly burden both Blake and the court itself. And here's a little twist. Every single argument that Wayfair raised has allegedly been available to them since the very beginning of the case. That's right, nothing here is new. Even though their counsel hinted at the possibility of filing a motion for judgment on the pleadings during a conference back on July 30th, they apparently waited until the very last possible moment. That last moment happened to coincide with the deadline for depositions in this case, which seems suspicious, right? They knew full well that because of their own shortcomings in discovery, Blake's attorneys would be busy preparing for and conducting depositions of 4 of the defendants at that same time. By the time Wayfair's motion is fully briefed, the deadline for summary judgment motions will be right around the corner. That timing is critical, because any fact-based challenges raised in the motion will almost certainly be overtaken by the record evidence that comes out during the summary judgment stage. Essentially, Wayfair is trying to convince the court that there are factual issues in the pleadings when, in reality, a judgment on the pleadings only deals with arguments of law, not facts. There's literally nothing in their motion that suggests there is a legitimate factual dispute. In fact, in their own document, they acknowledge Blake's allegations as true, and then pivot to argue why those pleadings shouldn't be allowed. Now, here's a big point. The claim that this motion is untimely or late is actually false. Why? Because a judgment on the pleadings can only be filed after the pleadings have officially closed. And Blake herself admits in the same filing that she had to submit multiple complaints over time. Her first complaint was filed on December 31st, the second on February 18th, and the third, which was actually her second amended complaint, was filed on July 30th, 2025. So, when it comes to judgment on the pleadings, it's important to remember that this is something that happens after pleadings are closed. It's entirely different from a motion to dismiss, and not the same as a summary judgment. Let's break this down. If Blake filed her second amended complaint on July 30th, then the defendants would have had 2 weeks to respond, which would place the response deadline around August 13th. Following that, her response would have been due about a week later, around August 20th or 21st. That means there wasn't really a delay on their part. Considering they had to conduct depositions and manage other case responsibilities, filing a motion for judgment on the pleadings would have required some time, but we're talking only 6 weeks after they filed their answer. And here's the legal nuance. You simply cannot file a judgment on the pleadings until after you've filed your answer. Now, Blake's attorneys also included a footnote in their filing, and remember, judges generally don't rule based on footnotes, where they accused Wayfair of being sloppy because one of their pleadings allegedly failed to address Title VII exhaustion. According to Blake's lawyers, this issue is actually an affirmative defense that was never raised by the defendants. Essentially, Blake's legal team argues that not only was this motion inappropriate for a Rule 12 motion, but because the defendants failed to assert this defense in their answer, Blake would be entitled to judgment on that particular defense instead of Wayfair. To further illustrate the point, Blake amended her CRD, California Civil Rights Department, complaint and received a right to sue letter with respect to EWM during the pendency of this action, which, according to her attorneys, satisfies the requirements. They don't specify exactly when the amended CRD was received, but based on publicly available information obtained via FOIA requests, it's clear that you cannot amend a CRD once the action has been closed. That means if she filed her CRD complaint and it was closed on the same day, reopening it would have required filing a completely new action with the California Civil Rights Department. And as expected, she would have had to provide Wayfair with a copy of this new complaint. Highly importantly, if Wayfair had already received this right to sue notice from Blake, they likely wouldn't be asking the court to dismiss the case. And if she filed it after all this, it would have been more than 300 days after the last incident of alleged harassment, which is way past the normal statutory deadline. If she updated her complaint recently, it's essentially inactive, and if she didn't provide Wayfair with the update, that's on her, not on them. In fact, Wayfair already had a copy of her CRD complaint as part of discovery. So the timing and details of this amended CRD filing are being questioned by many legal analysts. Blake's attorneys spend a significant portion of their filing arguing that moving forward without addressing this motion could delay the trial. But they also admit that the real question at this stage is not what the pleadings say, but what the actual evidence will show. And the proper way to address that question is through a motion for summary judgment, not by denying judgment on the pleadings outright. To complicate things further, they argue that even if the motion only raises legal issues, any minor delay in briefing would not prejudice the defendants. So here's the irony. On one hand, Blake's team claims the motion has no merit and the defendants shouldn't even get to make these claims. But on the other hand, they also suggest that if this gets delayed until summary judgment, the defendants could still present these claims. The reality is, if it's strictly a pleading issue, it doesn't need to wait for summary judgment. Summary judgment allows evidence to be introduced from discovery, including documents, depositions, text messages, contracts, and even video evidence, all of which can help the court decide who has the stronger case. Of course, it's fair to say that both sides are expected to seek summary judgment at some point. That's standard in complex civil litigation. Blake's filing even hints that she wants to bring in additional evidence, which is a bold move considering fact discovery has officially closed on September 30th. That means the period for gathering evidence from depositions and document review is over. The only remaining steps involve a few additional depositions and expert discovery. Her frustration seems to stem from the fact that the defendants want to get rid of the case now before she can continue amending or adding evidence. But the truth is, it's unlikely that Blake's attorneys can provide a full response, especially since her filing barely addresses the FEA, Fair Employment Act, claims. We're seeing a filing that focuses more on procedural arguments, like the timing of the motion and the right to sue letter, rather than addressing whether her claims have legal merit. The discussion touches on the right to sue letter but completely sidesteps the bigger issue, the extraterritorial application of the FEA. When I checked the California Civil Rights Department's own website, it was crystal clear. A right to sue letter issue there applies only in California. It's not a New York ticket. It's not a New Jersey ticket. It's a California ticket. Blake lively knew she had a California right to sue letter, yet instead of bringing her case where it actually belonged, California, she dragged it all the way to New York. Now, they point out that under federal civil rules, a party can move for judgment on the pleadings after they're closed, as long as the timing doesn't slow down the trial. But here's the catch. This motion isn't slowing anything down. In fact, the opposite is true. If the judge refuses to even consider it, the court risks going to trial with a case that's not even legally valid. That's not just inefficient, it's a complete waste of time, money, and taxpayer resources. The defense argues the motion is untimely because the issues raised were always available since the very first complaint, yet weren't filed until September 26. The court says this delay is excessive, especially since they want a trial by March 9, 2026. But let's be honest, is that really excessive? Absolutely not. Remember, Jed Wallace already filed a motion to dismiss. Discovery deadlines here are ridiculously tight. And trying to push a massive, complex case with multiple defendants, countless depositions, and enormous amounts of evidence, all the way to trial in just over a year is nearly impossible. Anyone familiar with federal court knows trial dates almost always get pushed back. Expecting the very first scheduled date to actually stick? That's naive. The opposition tries to paint this as fact-heavy, saying the motion challenges the sufficiency of allegations. But that's flat out wrong. Asking the court to rule that the FHA doesn't apply outside U.S. borders isn't a factual debate, it's purely legal. Same thing with fair report privilege, litigation privilege, or the civil conspiracy claim. These hinge on law, not fact. And if the legal foundation crumbles, the entire case collapses. They wave off the arguments as meritless, but notice something, they don't even say which ones. That silence says a lot. Then they claim the timing issue is mostly moot, because discovery has already uncovered voluminous evidence. But here's the problem. Evidence doesn't matter if the legal pleadings don't hold up. If the claim itself isn't legally viable, no amount of evidence can save it. Even more shocking, they suggest Blake should be allowed to amend her complaint now that she's gathered new facts. That's basically an admission that they're worried. They know these pleadings are vulnerable. And if the court lets her amend, that blows discovery wide open again. You can have mountains of evidence, but if the legal claim isn't allowed under the rules, none of it gets through the courtroom door. None of the arguments they're throwing out actually carry any real weight. They want to make it about a right to sue letter, but they completely skip over the bigger issue, the extraterritorial application of the FEA. And here's what I did. I checked the California Civil Rights Department's official website. A right to sue letter there lets you bring a lawsuit in California. Not in New York, not in New Jersey, only California. Blake lively knew she was holding a California right to sue letter, but instead of filing where it actually belonged, she dragged it across the country and planted it in New York. Now, they argue that under federal civil rules, a party can move for judgment on the pleadings once the pleadings are closed, but only if it doesn't delay trial. Here's the truth. This motion does not delay trial. In fact, if the judge ignores it, the court risks wasting everyone's time by pushing forward a case that isn't even legally sound. That's not just inefficient, that's reckless. It makes way more sense for the court to decide right now whether these pleadings are even valid. If they're not, why would anyone, the lawyers, the parties, the taxpayers, pour time and money into a trial built on quicksand? The opposition says the motion was filed too late. They claim all these arguments were available from day one, when the initial complaint was filed, and yet the defendants waited until September 26 to raise them. The court looks at the March 9, 2026 trial date and calls that delay excessive under Rule 12c. But let's pause. Was it really excessive? No. Jed Wallace had already filed a motion to dismiss earlier. Discovery deadlines here are brutally tight. And honestly, trying to force a complicated case like this to trial in just 14 months? That's absurd. We're talking multiple defendants, dozens of depositions, and mountains of evidence. Anyone who's ever followed federal litigation knows the first trial date almost never holds. Trials get pushed, it's normal. Pretending this one won't is just fantasy. Then comes the claim that the motion raises fact-heavy challenges to the sufficiency of the allegations. That's flat out wrong. Saying the FHA doesn't apply beyond U.S. borders? That's not a factual question, it's a legal one. Fair report privilege and litigation privilege, which go to the defamation claims, are legal doctrines, not factual disputes. The civil conspiracy claim? It collapses automatically if the underlying legal claims fall apart. Again, that's law, not fact. These aren't nitpicky factual fights. They're structural legal arguments. The other side weighs it all away as meritless. But notice, they never actually explain which arguments are supposedly meritless. That silence speaks volumes. They then argue timing doesn't even matter anymore because Blake has voluminous evidence from discovery to support her claims. But let's get real. Evidence doesn't matter if the legal foundation isn't there. You can't pile bricks on top of sand and call it a house. If the claim itself isn't legally recognized, no amount of evidence magically makes it valid. And here's the big giveaway. They ask to amend the complaint again now that they've gathered more discovery. That's not confidence, that's fear. That's them admitting the current complaint is weak and might not survive. And if the court lets them amend, that reopens discovery. We're back to square one. Endless time, endless cost. And again, evidence doesn't matter if the pleadings don't legally hold water. If Blake really wanted FHA claims to stick, she should have filed the case in California. She didn't. Now she's asking for a second bite at the apple. But you don't get infinite do-overs just because you don't like where the law leads. The court would have to evaluate any amendment under Rule 15's futility standard and the original pleading under Rule 12b. 6 as plausibility test. And even if the evidence is looked at in her favor, that doesn't fix the core problem. She's trying to win on evidence where the law itself doesn't support her claims. That's backwards. It'd be like Wayfair coming back after losing and saying, "Wait, Judge, we found new evidence. Please reopen our case." Courts don't work that way, and if the roles were reversed, you can bet Blake would be furious. Then they claim considering this motion causes delay. No, it doesn't. The defendants don't suffer prejudice by having the motion evaluated now before discovery snowballs even further. Summary judgment is about evidence, yes, but pleadings are about law. If you clear out the claims that shouldn't even exist legally, you save everyone from the pointless exercise of arguing evidence for a claim that was never valid in the first place. They also argue Blake will be prejudiced because she has to essentially prep for a summary judgment fight while discovery is ongoing. But let's be real. How many times has Blake herself caused delay in this case? How many motions for sanctions or attorney's fees has she filed, forcing Wayfair to stop what they're doing and respond? She's the one flooding the docket with delay tactics, not them. And now she claims she'll be forced to scramble because discovery is producing new evidence daily. That's not unique. That's literally how discovery always works. There's always the possibility of a motion on pleadings mid-discovery, or even a pending motion to dismiss. That's normal litigation life. At the end of the day, what she's really asking is, please deny this motion outright, call it untimely, and don't make me answer it. Or at least give me more time. And not just more time. She wants to limit her deadline to just 5 days after summary judgment pleadings are due, which would jam the schedule and guarantee more delay. This is classic stall tactic. And while she's crying, delay, 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 here's the kicker. All the core events she's complaining about didn't even happen in California. I looked into It Ends With Us, the movie. Yes, the company says it's based in California, but they opened a branch in New Jersey. Not only that, they received $12 million in subsidies from the state of New Jersey and in return, pumped over $34 million into the local government and community. All the work, all the filming, all the location activity, it happened in New Jersey. So how is she going to prove she's entitled to FVA coverage outside California courts when none of the key events even took place there? She's not. This is why I think Blake knows the case could eventually implode. That's why she keeps saying, well, even if the pleadings are faulty, I've still got evidence. But evidence can't revive a dead claim. Wayfair might just treat her filing like an opposition and respond accordingly because the motion itself is basically Blake begging the judge, please don't deny this on the merits. Just call it late. And if you don't, please give me more time. And if you still don't, at least let me amend again. But here's the truth. You don't get to endlessly amend. If she really had all the evidence she claims, it would already be in her second amended complaint. It's not. If she truly had this evidence, she would have asked the court earlier for leave to file again. She didn't. And the so-called evidence she has now doesn't prove what she wants it to. The heart of it is this. Retaliation claims must be pled as actual retaliation tied to actual employment. And she wasn't even an employee of It Ends With Us by the time of the premiere or August 2024. Her contract was done. She was no longer on the payroll. That's not a legal retaliation claim. And here's the update. While I was recording this, the judge actually issued an order. First, He had said Wayfair had until tomorrow to respond. But then he changed it. He said, "You know what? Forget going back and forth on paper. We're doing this in court." So now, on October 3rd at 2 p.m., there's going to be a live hearing via Microsoft Teams. The court will even post a public dial-in number so the press and public can listen in. Full transparency. Why is that important? Because Blake wanted the judge to just deny the motion outright on a technicality to skip the whole discussion. The judge said no. He's taking it seriously. He's not buying her narrative that this is just a delay tactic. Instead, he's cutting through it and saying, "We'll handle this now. Quickly. In court." And that's huge, because the hearing will cover the critical questions. Did she actually exhaust her FVA remedies? Does she even have standing for damages? And did she properly plead retaliation? These are make-or-break issues. So, Blake doesn't get to just throw a fit on the docket and hope the judge rubber stamps it. She and her lawyers will have to show up, argue in real time, and face the court directly. So what do you think? Drop your thoughts in the comments. Don't forget to like the video, subscribe if you haven't already, and click that bell so you never miss an update. Thanks for watching, besties. See you in the next one.